Hello, welcome to our unit on civil liberties and civil rights. The primary objective of this unit is to lay out some of the key differences and questions which relate to these seemingly interchangeable concepts, which are actually quite different and may project and imply competing conceptions of what the purpose of government should be. It is critically important that students are able to distinguish between civil liberties, which are personal freedoms, individual freedoms that the government agrees to not infringe, um, and civil rights, which are essentially guarantees, federal protections. So, on the one hand, civil liberties imply a certain freedom from government, whereas civil rights imply a certain protection uh, through the mechanism of government itself. At the heart of these distinctions lies the question of whether the government should do more or whether the government should do less. Should we have a bigger government that protects more rights? Should we have a smaller government that leaves more personal freedoms to individuals? And beneath the surface, there are also some less obvious but maybe equally important issues as pertain to the impact and outcomes of policies which prefer individual liberties as opposed to more civil rights. Generally speaking, civil liberties concern personal freedoms which the American government cannot infringe. Most of them are actually found in the original 10 amendments of the Constitution, the Bill of Rights. They are understood as limitations on the power of the federal government. As you may remember, the Bill of Rights and the addition of these protections on personal freedoms was a result of America's and certain groups that came to be known as the Anti Federalists. It really derived from the suspicion of these folks um, as regards the power of government. They were afraid that the federal government would become too large, and so they insisted on including a Bill of Rights and a set of protections, enumerated civil liberties and freedoms that would protect individuals against federal action, against a federal government that may be too powerful. Freedoms like freedom of speech, freedom of religion, the right to habeas corpus. These were some of the really instrumental components of the Bill of Rights and really some of the pillars of American civil liberties. They existed in theory, really, um, but through studying American history, we have seen that some of these freedoms in practice have been suspended under certain historical contexts. And so, as we begin to study civil liberties, we have this distinction between theory and practice. The theory we can see laid out in the United States Constitution, how these laws are explained, articulated, and enumerated. But it's only by studying history that we can see how these are actually applied in practice. And in practice, what we see is that, once again, some of these freedoms can be restricted, curtailed, um, or otherwise infringed. One of the more notable examples, and this is a picture, a slide from a Japanese internment camp called Manzanar, which is actually at the foothills of the Sierra Nevada in Bishop, California. It stands as a stark reminder that the right to habeas corpus um, has been has been taken away by the federal government from people who are in times of war, in this case, suspected of being um, foreign agents or might otherwise jeopardize the war effort or the security of the United States. And although many of the Japanese that were interred during the Second World War were, in fact, born in the United States and never been to Japan, um, they were nonetheless put into essentially what were concentration camps through the remainder of the war, losing much of their property and certainly being deprived of their freedom simply because of their race and their ancestry. And so, even though in theory the Bill of Rights may have applied to them and they had certain protections, one being the right to habeas corpus, the right to a fair trial, the right to due process. In this case, those rights, those civil liberties were suspended because the United States was at war, and the federal government did not feel it prudent to risk um, having the Japanese uh, obstruct the war effort. Interestingly, this was despite the fact that over 30,000 Japanese Americans actually served in the United States military during the Second World War. And this trend of suspending civil liberties has been something that's been repeated throughout American history. In the During the First World War, censorship, the freedom of speech was was closely monitored, um, and Americans who spoke out against the war or against the government could be tried for sedition. Again, so even though we have these civil liberties such as freedom of speech, there have been periods in American history where that freedom hasn't been absolute or as broad as maybe theoretically we can imagine. So we have these notable examples during World War II, during World War One, and throughout American history. Wars have often been accompanied by um, policies and legislation which affect civil liberties. And we have seen a curtailment of civil liberties during times of war. We saw this um, as war was waging in France, and the early republic was torn between entering on the side of the French or not. During that time, John Adams famously came up with the Alien and Seditions Act, which once again curtailed freedom of speech. Um, and we've seen that cycle repeat itself during the Civil War. Abraham Lincoln suspended habeas corpus in Washington, D.C., um, uh, giving the federal government the power to imprison people during the war without trial, um, under the auspices that they may be overtly or covertly trying to obstruct the war effort. I think the most important punchline of this is that even though we have these civil liberties and they are articulated and enumerated in the U.S. Constitution and the Bill of Rights, their application in practice has not been absolute. And especially in times of national trauma and war, the threat is that these privileges and immunities and personal freedoms can be suspended under the right circumstances and the right conditions. Most notably, too, in this slide, the poster all the way on the right, you can see an envelope, a mail envelope. Um, the government actually during the First World War would open mail that was sent internationally. So not just freedom of speech, but there's a kind of a tenuous nature of privacy. Frequently, the government is not just concerned about overt speech, but private speech, the private activities, and the surveillance of the kind of the private communication of citizens has been the subject of federal concern. Something that not just affects public speech once again, but the private sphere. For many Americans, these are examples for why we should not trust government, and that an overeager an empowered federal government, which is too big and too intrusive, uh, fundamentally threatens the individual liberty of Americans. And so these folks, and rightfully so, are mistrustful of this kind of absolute power of the federal government. And they look for the Bill of Rights, and they'll frequently cite civil liberties as these quintessentially American freedoms, which should never be violated, which should be absolute and broad, especially in times of national trauma, especially in times of war. They will say that it is not proper for government to intrude on freedom of speech, habeas corpus. The federal government should never be able to censor speech, open mail, um, surveil the public, violate uh, customary laws of privacy. They're suspicious of these types of actions. And history has not been kind to administrations that have suspended civil liberties. And so this reflects, again, this kind of mainstream American suspicion of government violating personal freedoms and personal liberties, and seeking a smaller role for the federal government in the lives of American citizens, American residents. It's also important to understand the broader implications of small government and individual liberty in the larger scope of American politics. Many of these arguments that really apply politically, personal freedoms, this notion of absolute liberty, have also been translated to the economic sphere. And so, um, in the realm of economic policy, one of these arguments is that while the federal government should not deprive individuals of their political liberty, it also shouldn't deprive Americans and American corporations from their economic liberty. The idea being that big government, intrusive government, that is too involved, is a bad thing. It's a bad thing politically. It violates personal liberty. It's bad economically. It violates economic liberty. Um, and so critics of big government will frequently cite the political arguments against uh, big government in order to promote more libertarian economic policy. Things like regulations on the environment, um, being one of the kind of the key points of contention there. And it's important to refer back to early American history and to the founding documents here. Part of the reason why we get the Bill of Rights, why we have this attachment to personal liberty um, in our political consciousness, derives from the Declaration of Independence, the American Revolution, these ideals of that time period, the ideals of the early republic, freedom, individualism, liberty. Some of these things are really important, and their reign in the American political system and in the American political consciousness is much older than the inception of civil rights. Generally speaking, civil rights derive from the post-Civil War period. They're a lot newer. Their configuration and their structure are unique from how we articulate and enumerate civil liberties. Civil rights are certain legal protections which are guaranteed by the federal government. The most notable ones, well, the most notable one really is the 14th Amendment. But the three key ones that come after the Civil War are the 13th, 14th, and 15th Amendments. Um, these are known as the Reconstruction Amendments, but it's really the 14th Amendment that develops this notion of equality under the law that is uh, familiar to and takes principles out of the Declaration of Independence and applies them to a definition of American citizenship. basically saying that citizenship is defined by equal protection, certain privileges and immunities, um, and that these are based on equality under the law. Now, these are rights and protections, and they have evolved and expanded over time. What's really important to understand is that the vast majority of civil rights have been a result of congressional legislation, meaning that the federal government has taken on more responsibility, more power, not just in legislating, okay, making new laws, but also enforcing them. One of the kind of novel things about the 14th Amendment that distinguishes it from the Bill of Rights is that the 14th Amendment gives the federal government the power to enforce new laws. Remember that the Bill of Rights is really an acknowledgement by the federal government that they will stay out of um, certain personal matters, speech, religion, and so on. Civil rights are protections. They imply an expanded role for government. And the more civil rights we have, broadly speaking, the more government we need in order to protect and guarantee those new rights. And so this slide is actually taken. Um, it's a desegregated classroom. Segregation is something that is outlawed uh, eventually in the 1950s. But the law itself derives from the 14th Amendment, civil rights legislation. It's due to civil rights legislation and this new power that the federal government has that is going to, well, it's going to coerce certain states to desegregate. It's going to force them to desegregate and provide this kind of equal opportunity to Americans, irrespective of things like race. Now, hopefully, at this point, students can understand that civil rights and civil liberties are a sort of game of give and take. Civil liberties implying smaller government, civil rights implying a broader role for government, we can see how objections can be derived to each, right? For someone who favors civil liberties more, they will say, well, government is doing too much. It is obstructing personal freedom. It is too big. It's too bloated. We should be, as Americans, suspicious of the federal government. On the flip side, somebody that is believes that government should do more, should be a tool, um, should adjust to the needs of society, should address social crises, one being segregation, they will say that the federal government doesn't do enough, that the federal government's power to expand civil rights to protect disproportionately impacted citizens should be broadened. It should be something that doesn't just pertain to classes defined by race, but should be extended to other minority groups that require special protection by the government. And so this is why the 14th Amendment has been the most heavily litigated uh, amendment to the Constitution since being added. Um, Trying to pin down and establish things like privileges and immunities, trying to define what equality under the law really means and to what extent is America, the federal government, obliged to extend that protection to not just racial minorities, ethnic minorities, but other social minorities. Um, the LGBTQ community, should they enjoy the same types of privileges and immunities of the citizens of the United States? So these are some of the really, really important questions that are being litigated um, by constitutional lawyers today. And so it is the 14th Amendment that we really associate with the expansion of civil rights. The date is important, 1868. So this is almost 100 years after the Constitution is drafted. It's about 80 years. Um, what's important about the 14th Amendment, even though we associate it with the civil rights movement, um, we frequently associate the civil rights movement not with the 1860s or the 1870s, but with the 1960s and the 1970s. And the reason for this is that it's going to be interpreted differently by the Supreme Court. Over time, this amendment will evolve and its meaning will change. Its legal meaning and its legal implications will change. Some of the important questions that the 14th Amendment dealt with, um, it defined citizenship for the first time, and it based citizenship on the equal protection of the law. And this is really important. It's the first time that equality, the word equality, um, as it pertains to individuals, first shows up in the Constitution. So, equality under the law, due process of the law. But the 14th Amendment did other things. Um, one of the big things that the 14th Amendment did is it answered this question of, well, did the Bill of Rights actually apply to state governments? And this may seem trivial, but it's actually really important. Initially, um, the understanding of the Constitution was that it applied to the federal government. It limited federal power. And so while there was a Bill of Rights that protected religious practices, freedom of speech, that only pertained to the federal government. And states, it wasn't clear like whether states could actually challenge or violate some of these principles. So could states censor individuals? Could states have established religions? So that wasn't clear until the 14th Amendment, and it was only the 14th Amendment that came back and said, yes, actually the Bill of Rights does not only apply to the federal government, but also the state governments. So state governments cannot violate the Bill of Rights. And you can see how this is important because it's now beginning to introduce and apply some of those protections of the Bill of Rights to African Americans and minorities. The second important thing about the 14th Amendment is it wouldn't have come along without the Civil War. The Civil War is this really profound national trauma. Um, it's important to understand the Civil War not just socially, but in a political context. Um, as a result of the Civil War, uh, the federal government comes under the control of the Republican Party. The Republican Party is kind of a new party in American history. It really it's born in the 1850s. The first Republican to hold the presidency is Abraham Lincoln. When he's elected in 1860, uh, many of the southern states that are going to become the Confederate states um, leave the Union. Um, but because of the sectional crisis, there's already this dichotomy politically. In the South, most of the southern states are controlled by the Democratic Party. Most of the northern states are controlled by the Republican Party, or they vote Republican in 1860. When the southern states secede, they are essentially leaving. They essentially and literally leave Washington to form their own country, and so it leaves the Republicans in charge. When the war ends, these Democrats from southern states, they're not allowed to come back to Washington and engage the legislative process. And so during Reconstruction, the reason why the federal government is able to pass these three amendments in very short order, remember how difficult it is to amend the Constitution, very difficult. The reason why they're able to do this is because there's essentially no political opposition. The Republicans have a monopoly over political power at this point. Not all the southern states have been brought back into the Union. And it's going to be by um, agreeing to abide by these new amendments that they're actually going to be brought back. It's going to be conditional. So on the one hand, we see these as a Republican political construct. It's this Republican monopoly, this Republican majority, uh, super majority in Washington that passes these amendments. It's important to see it also from the perspective of the political opposition, the Democrats, the Southerners, they don't see this as an inclusive process. They won't accept these. They're going to push back against them. Um, they see them as unfair. They see them as legislation that's going on without their consent. And so there's going to be considerable political pushback. They also see this as self-serving. They'll say, Southern Democrats will say the reason why the Republicans are granting black citizenship, why they're giving blacks the right to vote, is not for any moral or ethical reasons. They're giving blacks the right to vote because they expect that these blacks will vote Republican. So they really see this process being perverse and corrupt, and they're not going to accept it. But nonetheless, the 13th, 14th, and 15th Amendments, which are meant to settle this question of citizenship, and especially black citizenship, are really just the beginning of what is going to be this battle for civil rights. It's going to have considerable ebb and flow. Um, what's also important to understand is that even though the 14th Amendment is ratified in 1868, it is preceded by a Civil Rights Act. And the Civil Rights Act is contentious. The president, Abraham Lincoln, has been assassinated. The president is Andrew Johnson. And Andrew Johnson he's from Tennessee. He's a Southerner. He's one of the few Southerners who remained in Washington during the Civil War. And it's a testament to Lincoln's unpopularity that in 1864 he has to add Johnson to balance his presidential ticket. It's not a foregone conclusion that Lincoln will be reelected in 1864. Well, he adds Johnson, the Southerner. He's assassinated, and now Johnson is going to be the president in charge of Reconstruction. And he's going to push back against civil rights. He's going to refuse to sign the Civil Rights Act, which is going to cause tremendous friction between the executive and legislative branches. Eventually, the Republicans in Congress are going to push through an amendment to the Constitution because the Civil Rights Act, it is apparent to everyone, is not going to be sufficient. Just this piece of legislation is not going to be enough. They feel like they're going to need to amend the Constitution itself. So this is important. Okay, the degree of pushback that the Civil Rights Act gets results in a more heavy-handed, a more radical Republican Party, a more radical Republican wing of the party pushing through an actual amendment to the Constitution. But so the 14th Amendment defines the nature of citizenship. It expands, and this is extremely important, it expands what it means to be an American. It makes the United States more democratic. Now, we're still not ready to give women the right to vote, okay? But we are making a radically more diverse polity, meaning that individuals who are slaves are now included. They're given legal status, they're able to vote, they're able to hold office. And so, what the 14th Amendment will produce, other than simply black voters, it'll also produce black statesmen. African Americans will go to Washington and serve in Congress. So, this is again really a radical shift. Um, it, One can say a traumatic and sudden shift, the turning of the tables. Not too long ago, the Confederate States are seceding in order to protect the institution of slavery, to subjugate African Americans and impose white supremacy in their section of North America. And now they're in a position where they have to not just, in some cases, share power with African Americans, okay, but capitulate and actually live in a potentially in a congressional district that is represented by an African American in Congress. Again, this is really quite a sudden turn of events in certain parts of the South. So even though Republicans are able to pass these amendments, they're not seen as legitimate. There are factions within the Republican Party. The Republican Party is so big at this point that there are some within the Republican Party that think that this is a bad idea. Um, so there are some radical Republicans that are they really believe in a punitive peace. They're going to make the South submit. They're going to be very heavy-handed. They're treating the southern states like they're traitors, and they're trying to be as punitive as possible. There are other legislators, politicians, political leaders that believe that the peace after the Civil War should be um, uh, it should be amiable to the South. The South, the southern states, should be allowed to rejoin the Union. After all, we're all brothers. We're all part of the same fabric. There should be a path towards Southern redemption, and it's really these folks are known as redeemers, right? And so the radical Republicans are looking for a more punitive form of a peace settlement. The redeemers are looking for something that's going to uh, build more of a consensus and welcome the South back into the Union. Um, it's really important also to understand that the nature of the war, there really isn't um, a peace settlement. The peace settlement for the war, it really is the 14th Amendment. Um, and so its legitimacy, how it's going to be applied, is really the source of great debate and negotiation. Um, the process of Reconstruction in the South, part of the reason why the legitimacy of the 14th Amendment really wanes, is that Reconstruction, Southerners push back against Reconstruction. The saying that historians have is that while the North wins the Civil War, the South wins Reconstruction. The South pushes back against the political Reconstruction of the South in the image of the North, as well as the economic Reconstruction of the South. Um, the damage that is done to the South as a result of emancipation is absolutely devastating. And so it enters a period of economic depression. One of the results of this economic depression is that Northern industrialists begin to go down south to participate in the economic reconstruction. They're going to build factories, they're going to open businesses. Um, these folks become known as carpetbaggers. A carpetbagger is extremely negative, pejorative term in the South. It's a northern opportunist. It's an outsider, a foreigner coming down south in order to profit from the economic devastation of the South. So these outsiders, they push back against them. Again, it may seem kind of counterintuitive because it's um, this outside capital, it's capital infusion that's coming. It's this direct investment in the reconstruction of the South, but socially, politically, Southerners push back against this. This is just another form of invasion. The other term is a scallywag. A scallywag is a southerner, a southern opportunist. Rather than pushing back on Reconstruction, the political elements of Reconstruction, they are capitulating to it. They're cooperating. They're opportunistically using these newly emancipated African Americans, Negro voters, sometimes against their will, if for their own political advantage. So a scallywag would be even worse than a carpetbagger because scallywag is one of the South's own. It's one of their own who, instead of continuing to obstruct and resist Reconstruction, they're capitulating to it. They're taking advantage of it at the expense of their fellow Southerners. So Reconstruction, there's tremendous resistance to it. There's huge societal, political, and cultural pushback against this. And as Southerners are pushing back, um, what ensues is a depression. A Great Depression hits the United States in 1873. Um, and basically the long and short is that the depression causes a pullback by the Republican establishment. They basically agree to stop Reconstruction in the South. They're going to withdraw the army, and they're going to allow for a return to home rule, meaning that um, many of the folks that were part of the leadership that formed the Confederate States, some of those folks, rather than being tried for treason or being kept out of positions of political leadership, they're going to be allowed to return. After all, you need qualified political leaders. Um, and what the consequences of this return to home rule, the Democratic Party they actually take back many of the state legislatures. Um, Political voter turnout by African Americans plummets. Initially, it spikes after the Civil War, but then as home rule returns and as states begin to segregate and create laws that will allow for the marginalization of African Americans, poll taxes, literacy tests come back in order to exclude blacks from voting, um, black voter turnout will plummet. The Democrats will recapture city state politics, and as well as return to power um, in Washington. And this will really be devastating and will call into question um, the uh, the power and the authority of the federal government in order to enforce the 14th Amendment. This idea of equality will become again undermined by a series of state laws, city and state municipal laws that collectively will be known as Jim Crow. Now, Jim Crow laws across the South will institutionalize the practice of segregation. Um, this idea that the races must be kept separate. And so we will see um, uh, African Americans be really relegated to the back of the bus, the back of um, uh, the back of restaurants. They won't be able to sit at certain lunch counters. Certain places won't serve them. Um, Things like highway rest stops will be segregated. Segregation will really spread throughout the South. Um, but there are folks that see the see the legal problem in this. And so they're going to challenge this idea of Southern segregation. They're going to challenge Jim Crow at the highest level in the Supreme Court. And the most famous case is that of Plessy versus Ferguson. Now, most of us remember um, Rosa Parks, right? Rosa Parks, the Montgomery bus boycott. Rosa Parks is a civil rights hero because she's the one that defies these laws of segregation, Jim Crow, by sitting in front of the bus and not moving to the back when a white passenger comes on board. Plessy versus Ferguson does this almost 60 years before Rosa Parks. And it's one of these Supreme Court cases that is set up in order to push this idea of segregation to a Supreme Court, to a constitutional test. Um, Basically, the situation is similar to Rosa Parks in the sense that an African American gentleman, now it's noteworthy here that this African American gentleman, he's 1/8 black, and these states have they all have these different codes on what makes you African American. In some states, I believe in Virginia, if you were 1/16 black, that made you black. Um, in other states, if you're 1/8 black, that made you black, and so this gentleman is 1/8 black, and so even though he's light skinned, he's nonetheless black. He sits in the front of a streetcar. He's arrested by the local police. They're actually in on this case because they intend to push this and challenge this idea of segregation. And so this case, Plessy versus Ferguson, makes its way to the Supreme Court. Um, and basically, in 1896, the Supreme Court, the highest court in the land, affirms this idea that segregation is legal. Segregation is legal, separate but equal. This standard meets the standards set forth by the 14th Amendment. So when we say that Americans enjoy the equal protection of the law, the Supreme Court says yes, and as long as there are accommodations, they can be separate. Okay, and separate but equal meets the requirements, meets the standard for the 14th Amendment, and this will really push and embolden Southern states um, and cities in the South to really ramp up all sorts of laws that will now segregate society, segregated schools, segregated facilities of all sorts, segregated drinking fountains, bathrooms. Society in the South becomes segregated, and it's noteworthy that society in the North is segregated as well. So segregation really begins to define this idea of legal equality, and it will be this way um, for about 60 years. So this is really important. So this period of about 60 years after Plessy versus Ferguson is really kind of the golden age of segregation, the golden age of Jim Crow. Even after the even after the Civil War and the 14th Amendment, we're not really sure the legal status of segregation until it's affirmed by Plessy versus Ferguson. And it is one of these really uh, negative moments, down moments for the Supreme Court. It's seen as kind of one of the worst decisions in the history of Supreme Court, right up there with Dred Scott. And it will take nearly half a century for this ruling to ultimately be reversed. But for the time being, segregation is something that's legal in the United States. To understand Brown versus Board, I think it's so important to understand that Plessy versus Ferguson has this momentum. And this momentum begins at the turn of the 20th century and it will carry. Segregation has this energy, this dynamism. It spreads, it is a force going into the 1850s. And it is monumental that in 1854 the Supreme Court gets another one of these civil rights cases, Brown versus Board. Can schools be segregated? Is separate but equal really legal in the United States? And the Supreme Court here in 1854 will basically rule that no, separate but equal does not meet the standards of the 14th Amendment. They basically issued a ruling that separate is fundamentally, as it says here, inherently unequal. Okay, and so even though legally speaking, segregation at that point is outlawed, this momentum, this energy that this movement has, and it's been spreading. Okay, segregation is a fundamental element of society in America, in certain parts more than in others. But segregation is really what allows, well, kind of certain parts of the South to maintain what they believe to be their identity. And so now the Supreme Court is going to render it illegal, but these states are going to push back. And they're going to push back because they believe that is their right to push back. And it's not for the federal government to come in and tell them how to run their schools, run their buses, run their some of these municipal services. So even though it seems as though Brown versus Board really settles this question legally, again, it's only the beginning. And once again, I have to reiterate, we don't really think about the civil rights movement until the 1960s. Brown versus Board comes in 1954. So this is a very slow moving thing. Um, the federal government will take steps to force desegregation. One of the most famous examples is in Alabama. Alabama has a prominent segregationist governor, George Wallace. He's seen in the right, um, and he is going to stand up against forced desegregation. And here he's standing in the door of um, uh, a educational institution in the South, and on the other side are, well, they're actually federal troops are coming, and they're telling George Marshall, look, you're going to have to allow African Americans to attend these schools. And George Marshall, well, the state of Alabama doesn't have a military force, but they have a National Guard. They have not National Guard, but they have state troopers. They have certain state police, and so you can kind of see that the federal government has the troops on one side. You can't see the troops, but you can see the representative of the federal government there, and George Wallace standing defiantly with, well, with his troops, with his force. And it's these state troopers, it's these state policemen that are representing this kind of pushback, this resistance of massive resistance by the state of Alabama against this forced desegregation. So again, this is going to be a story that's going to um, develop. But there is on the one side the federal government that is now trying to enforce desegregation fighting against these states that have had segregation for 70 years. Um, and they've really defined their society based on these kind of segregated classes, segregated by race. And it's going to be, well, it's going to be a battle for them to agree, capitulate to this new federal policy, which they see as illegitimate. And I hope that students at this point can see some of the roots taking place of this debate between more government or less government. Folks that are inherently less government, more federal government, more states' rights, they will favor things like home rule, personal freedom, liberty, and see the role of government as being something that is oppressive. So we can see somebody like George Wallace in this case being somebody saying that, look, these civil rights, this new big government that's here coming with the military, that's a fundamental violation of Alabama's liberty and the citizens of Alabama. Why shouldn't the citizens of Alabama get to decide how their schools, how their public services are going to be run? On the other hand, we can kind of imagine that some of these new groups that are enjoying more protection and more opportunities, African Americans in the South that now get to go to white schools, they are seeing that, look, actually the federal government's not doing enough. I don't feel safe. In some parts of my life, there I see this overt racism, which is excluding me from certain opportunities. What's going to happen over time is that, well, the civil rights movement is still going to ramp, but what we're going to see is a broader application of the 14th Amendment. And this definition of equality under the law is going to expand. And it's not going to touch just things like education, where you sit on the bus, where you sit in a restaurant, where you stay in a hotel, but it's going to affect other elements of civil society. Some are going to be very overt and explicit, but other parts of the civil rights movement are going to be much more implicit. And it's going to take a long time and really careful observation to understand how it's being played out and how minorities are disproportionately impacted by a lack of equal opportunity under the law. And so I think it's very important for us as a class of political science to transition from the kind of the development of the civil rights movement, um, this this tension between civil liberties and civil rights, and have a kind of a more nuanced and delicate understanding of how minorities are impacted and how institutions of civil society can work against them, maybe not explicitly in the way that George Wallace is standing there in front of a schoolhouse, but more implicitly, in ways that are unseen, but maybe perhaps as damaging and as inequitable as the lack of equality and access to educational facilities, or the lack of equal opportunity in just sitting on a bus. Um, and one of the ways that we're going to look at that in this class is the access to housing. And that's going to be one of those ways where institutional racism and segregation is going to manifest itself more discreetly. It's going to be much more hidden. It's going to be less visible, but just as institutionalized as things like school segregation were. And so, just summing up, relatively speaking, civil rights are a newer phenomenon, and the civil rights movement is an even newer phenomenon than the civil rights, the laws that were on the books. Remember that those laws really derive from the 19th century, and the civil rights movement is a phenomenon of the mid 20th century. So, one of the big punchlines is how long it takes for these laws to actually reach a place where today in 2019, 2020, we find them recognizable. It takes a long time, it takes a century. Um, and it happens very slowly, very incrementally, involving tremendous pushback. And because these kind of institutions of segregation are so perverse and profound, um, and predominant, Again, they exist overtly, but they also exist covertly in parts of society that are not seen. Within this dialogue of civil rights and civil liberties, it's really important to understand this idea of disproportionate impact and the fact that not everyone is affected the same way by this dialogue of civil rights, civil liberties. Essentially, it's this: folks that need federal protection, right? Folks that need federal protection ask for more civil rights. They are harmed if those civil rights are diluted, if they're lessened, if the role of government is rolled back. Okay, and so this is one of these things that is at the essence of it. It's a little bit beneath the surface, but it's not just about big government and small government, because big government and small government affects different individuals, different parts of society in different and unique ways. And so this is important and an important recognition for us to keep at the front of our mind as we proceed into kind of our modern assessment of the theory and practice between civil rights and civil liberties, and trying to assess what that proper balance should be. How much personal freedom should we have? How much federal protection should we have in order to, well, guarantee some of the civil rights of individuals that have in the past not have equal opportunity, have not been equal under the law? This is, I think, the essence of this tension between civil rights and civil liberties.